Good afternoon, everyone. And my name is Shishir Srivastav, and I'm the mentor for Judiciary Masterclass with Rostrum Legal. Today, I'm here to discuss, rather, to tell you or to teach you about the relevancy of the statements of witnesses under Indian Evidence Act 1872. So, let's start with this concept and see what does the previous statement in writing is. What is the relevancy of the statement which is recorded during the investigation by the witness under Section 161 of the Indian Code of Criminal Procedure? Let's start with section 161 and 162. So first of all, 161 says that during investigation, the investigating officer can record the statements of witnesses. And it is the duty of the witness to truly answer all those questions, except those questions which has the tendency to expose them to criminal charges. And the investigating officer is also required to keep a record of every such statement, which are then reduced to writing. But then the proviso of the section also makes a provision that for the offences under section 354, 354A, B, C, D, and 376, which is the offence of rape, and the various variations of the offence of rape, which is given under A, B, C, D, E, or section 509 of the IPC, the statements of the witnesses should be recorded by a female police officer, keeping in mind the dignity. All these reforms have been incorporated by the 2013 Criminal Law Amendment Act of 2013 after the famous Nirbhaya gang rape case, post which the Union government constituted the Justice J.S. Verma Committee report, and it was on the basis of the recommendation of this committee report that these changes on the basis of the reformative report of that committee, these changes were incorporated into the section 161. Section 162 of the CRPC states that whatever statement is recorded by the investigating officer under 161, those statements should not be signed by the witness. It is prohibitory on the witnesses to sign the statements, because what happens is whenever the witness signs a statement, it becomes an evidence and it can be used as against the witnesses before the court in case if they do not want to support the prosecution theory before the court. If we remember that we have a fundamental right, each and every of us has a fundamental right under Article 20, Clause 3 of the Indian Constitution, which says that no person who is accused of any offence shall be compelled to be a witness against himself. So during investigation, it may so happen that apart from accused, some witnesses may be reluctant to give testimony before the police officers because it may have the testimonies may have the tendency to expose them to some criminal charges. And also the police brutality, which is very common. And recently we have seen the custodial torture case in the state of Tamil Nadu. So the police brutality to extort the confession from the witnesses or accused is also very common, and therefore to prevent them from all these brutalities and from to contain all these acts of the police authorities and to make the investigation quite legal, this provision has been made in section 162 that none of the witness statements should be recorded, which will be recorded and which will be reduced to writing. It should not be signed by the witness. The proviso is very important here. It says that such statements cannot be used for any purpose, but then the accused, without the permission of the court, and the prosecution with the permission of the court, can use this statement under section 161 for the purpose of contradiction under section 145 of the Indian Evidence Act. See, what happens is it is not necessary that if the police officer or the investigating officer during investigation has recorded your statement, it is not compulsion on you that you are required to withstood that testimony before the court. It may so happen that the police officer has compelled you to say something and he has written against your will, and therefore the chief examination is again done before the court, wherein the witness is at liberty without any coercion, without any duress, that he can reveal the true story, and he can also make an allegation on the police authorities that whatever statement was written was recorded by the police authorities under section 161 was not according to his will, to his or her will. It was out of compulsion. It was deliberately extorted out of the witness by the police authorities by compelling them under the fear of giving them some kind of threat or threat of injury or threat to the family members. So it sometimes happens that the prosecution witnesses before the court turns hostile. When they turn hostile, the prosecution under section 154 of the Indian Evidence Act has a right to cross-examine the hostile witness, and the testimony of the hostile witness is not to be rejected completely. The testimony of the hostile witness is relevant, and if the prosecution wants, he can cross-examine the hostile witness and can try to bring out the contradiction. Now, in this case, when the hostile witness is being cross-examined by the prosecution, then the prosecution can use his previous statements under Section 161, which were recorded for the purpose of contradiction under Section 145. Now, this is the case of prosecution where the witness turns hostile. The prosecution can seek the permission of the court for for cross-examination under Section 154 of the Indian Evidence Act. And when being cross-examined, the prosecution can try to contradict their own witnesses, their own hostile witness, with respect to their previous statements in writing under Section 145 of the Indian Evidence Act. Now, as far as the accused or the defense is concerned in the case, the accused or the defense, without the permission of the court, in case if there is any contradiction in the testimony of the witness with regard to what they deposed before the police under Section 161 and what they are deposing before the court in their chief examination, can be cross-examined without the permission of the court with regard to their previous statements in writing under Section 145 of the Evidence Act. The contradiction, for the procedure for bringing out the contradiction which has been specified in Section 162 is that first that statement has to be proved. Now, only when, whether it is prosecution or whether it is the defense, when they are trying to cross-examine or when they are trying to bring a contradiction with regard to the statements under Section 161, first those statements need to be proved before the court. Only then, whether it is prosecution or whether it is the defense, if they want to contradict, they can contradict under Section 145 of the Indian Evidence Act. Now, the exception to the rule in Section 162, which has been carved out, is with regard to the dying declaration under Section 32 clause 1 of the Indian Evidence Act, and any fact which has been revealed by the accused in the custody of the police and which leads to the discovery of any fact under which is relevant under Section 27 of the Indian Evidence Act have been excluded from the purview of Section 161. So it does not matter, in cases of dying declaration or in cases of discovery statements under Section 27 of the Indian Evidence Act, it does not matter whether those statements were recorded under Section 161 of the CRPC or not, whether those statements have been proved before the court or not, or whether it is going to be contradictory or not. If it is a statement, or if it is a dying declaration which gives an indication about the circumstances in which the death of the witness or the accused was, death of the witness or the injured was caused, or if it is the statement of the accused which is leading to the discovery of certain facts under Section 27, if it is leading to the discovery of certain facts, if it is leading to the discovery of certain facts, then it is always admissible under Section 167, no matter whether the procedure has been followed or not, and that is why this exception has been taken. Now, before moving forward, I would like to know from the audience whether you are able to understand what is being taught now, whatever has been taught till now. Please let me know in case if you are able to follow, if you have been able to understand whatever has been taught up till now. Please, guys, you will not be able to have a direct communication with me, so you can write yes or no in the comment section, so that I'll receive that message and I'll be able to ascertain whether you are being able to follow up the session or not. Right. Then moving forward, in the same case, Section 162 in its explanation has also detailed about what are the omissions and contradictions. And omissions and contradictions can be material and immaterial. Now, for example, what is the omission? I have stated something in the FIR. I have stated something in the first information report, or I have stated something in I've deposed something before the investigating officer under section 161 of the CRPC with regard to the commission of any offense. But I completely changed or quite altered my story when I'm deposing before the court. Say, for example, for the charges under section 326, which is the charge of causing grievous hurt with some dangerous weapon, especially being used for shooting, stabbing, or cutting. So if the grievous has been caused by either firing a gunshot on the injured, or by stabbing him with a knife, or by hitting him with a scissor or any other instrument which can be used for cutting, and if the grievous hurt has been caused to the injured or to the victim, then the charges under section 326 of the Indian Penal Code are maintainable. Now, for example, if I am the victim and I have registered an FIR, I'm stating that the accused hit me and he has caused me grievous hurt, and I've received the three incised wound, one on my left hand, one on my right hand, and the one on my head. But I have not mentioned by which weapon or by which instrument these injuries were caused to me. And later on, when I am deposing before the court, I altered a story, and I said, and I deposed before the court that I was hit by the accused with a knife, and these injuries have been caused to me with a knife. Now, this is a different fact altogether, that the court will seek the corroboration about the fact of injury from the medical report, about the possibility or the possible cause for the injury on my body. The point is that this is an omission. I did not mention it before the police authorities. I did not mention it in my FIR. I did not depose about I was being hit by a scissor, or I was being hit by a knife, or I was shooted with a gun. I did not mention about this fact before the police authorities. No, this is material, because if we look into the ingredients of section 326, and this is just for an example, I'm taking the example of section 326 just as an example to make you understand as to what can be the material omission. So if I did not mention this in my statements under 161 CRPC, or if I did not mention this in my first information report, which I am lodging with the police authorities, but I am using, I'm mentioning this fact in my deposition before the court in my chief examination as a prosecution witness, then obviously, as a reasonable person, a doubt will arise about the veracity of my testimony. Because if I was really hit by a scissor, or if I was really hit by a knife, or if I was really shooted by a gun, then I should have mentioned about this fact to the investigating authorities. Now, the charges under section 326 are only maintainable if I have been hit by some instrument used for shooting, stabbing, or cutting. So the investigation should also reveal something about it. So not only the medical testimony is sufficient, but also the fact that the weapon of offense has been recovered or not, whether the investigating authorities have seized the weapon of offense or not. But if I have not yet mentioned this to the investigating authorities, I did not make any mention about it in my 161 statement or the FIR, then how is the police authority going to come to know about it? And how the police authority will not how the police authority then will make an endeavor to search for the weapon of offense to corroborate my testimony or to substantiate my testimony before the court. So, not mentioning this information that I was hit by with a knife is a material omission, and it can give a reasonable suspicion to the defense and to the court about the veracity of my testimony, and the court will be safe to coming to a conclusion that whatever testimony I am giving is a concocted story, is an afterthought, and therefore the omission to mention the weapon of offense and mentioning the weapon of offense in the deposition before the court is going to be a material omission, and this material omission will be a material contradiction. Now, the fact as to what all facts are material omission or material contradiction are a matter of question of fact, which varies from case to case, and this is what is the explanation of 162 saying. Now, having said that, now it is time to ascertain the nature of these statements, which is recorded under section 161 of the CRPC, or even the fact about the first information report under section 154 of the CRPC. We must remember, guys, that whatever deposition which we are making before the investigating authorities under section 161, it is not a substantive piece of evidence. It has also been ruled by the Supreme Court in Catena of decisions that the statements given to the investigating authorities under 161 CRPC, and also the fact stated in the first information report under section 154 of the CRPC, They are not the substantive piece of evidence. But yes, similarly, when you are deposing before the court, and if there is some material omission or contradiction, then after proving those previous statements, so these statements under 161 CRPC and the statements of FIR under 154 CRPC can be used as previous statements in writing for the purpose of contradiction in the manner as stated by Section 145 of the Indian Evidence Act. And we have seen in detail in the previous slides that under Section 162, if you are about to cross-examine or if you are about to contradict the witness with regard to his previous statement in writing under Section 161 CRPC, then those statements need to be proved first before the contradiction under 145 can take place. So, is this point clear to everyone? Is this point clear to everyone? Right. Now, moving to the types of witnesses which are there, which is the second part of our session today. Now, there are various types of witnesses which can, which the prosecution can bring in support of their theories in the criminal trial. And these kinds of witnesses are not only applicable. The theory of the theory of the type of witnesses is not only applicable in criminal trials, but the same is also applicable in case of civil suits or civil proceedings. Because what ultimately we have to see in the dispute between two parties is the corroboration or the support of either of the parties by some independent witness. So the very first type of witness which we have in Evidence Act is the independent witness. Now, who are independent witnesses? The independent witnesses are those witnesses who are not related either to the complainant or to the accused in the matter which is before the court, whether in a criminal trial or in a civil suit, which means that the veracity of their testimonies cannot be questioned as a partisan testimony. And that is why those witnesses who are not either related to the prosecution, not related either to the accused in a criminal trial, or not related to the plaintiff in a civil suit, or not related to the defendant in a civil suit, will be called independent witnesses, and their testimony will have a high credibility in the eyes of law under Indian Evidence Act, because they are impartial and their testimonies can be relied upon because in either of the parties. So their testimony will have a higher relevancy. Now, for example, who can be an independent witness? So, say for example, if I am involved in a scuffle with the accused, and the accused is beating me, and I am making the allegation that the accused has beaten me. Now, if there was any bystander who is standing and witnessing the entire incident, he's neither related to me, he's neither related to the accused, but he has agreed before the police authorities to give testimony before the court with regard to the scuffle. Now, his testimony as a bystander will be an independent testimony. He will be called an independent witness. He will be called an independent eyewitness. But there may the witness happens to be on the place. They are by chance there. So, say for example, if someone has trespassed into my house and started creating ruckus, and I made a cry, and after hearing my cries, my neighbor came. So those neighbors on the spot of crime, which is my house at that particular point of time, will be called a chance witness. Now, the chance witness is a person who is not associated with either complainant or accused or the plaintiff or defendant, but he was present at the time of the commission of the offense. And for proving the credibility of the chance witness in the examination before the court, it is necessary to explain sufficiently his presence on the spot of crime, as to why he was there, what he was doing on that particular point of time when the offense was being committed, or when an act was being transacted between the parties. What he was doing when he's neither related to the plaintiff, when he's neither related to the defendant, or when he's neither related to the accused or neither related to the victim, what he was doing on that particular point of time. So this he needs to explain sufficiently before the court before his testimony can be relied upon. by the court as a chance witness. Now, say for example, if I am in the market, I'm in a vegetable market, and I entered into a scuffle with someone. So obviously, the bystanders there will be a chance witness because it's a marketplace. Anybody can be there, especially the vendors who are there who are selling their vegetables. They are the chance witness. They used to come there daily. It is their place to be. So they will be called a chance witness. Then the third testimony, the third kind of witness can be injured eyewitness. Now, it means sometimes happens that the victim is sometimes along with their friends or with their relatives when the assault on him took place. The assault not only injures the victim, but all the assault sometimes also injure the friends or the relatives of the injured or the victim, right? In those cases, they are the only eyewitness. Now, what will happen? Can the court say or can the defense make a plea कि नहीं भैया ये तो क्या कहते हैं इसका दोस्त है, ये तो खुद ही इंजर्ड है, ये तो क्या कहते हैं मेरे खिलाफ ही गवाही देगा, इसलिए इसकी टेस्टिमनी को बिलीव न किया जाए. Can this plea be made by the defense? And can this be a ground for the court to completely reject the testimonies of the injured eyewitness? They are ultimately the eyewitness. The prosecution does not have any other direct evidence to bring before the court to press upon the charges against the accused for conviction. So the question is, under these circumstances, when the injured eyewitness is the only eyewitness and there are no other direct evidences or eyewitnesses who are independent in nature, with the prosecution to bring before the court on record to press upon the charges against the accused for the conviction, क्या उन circumstances में, उन परिस्थितियों में क्या ऐसा हो सकता है कि injured eyewitness की testimony को completely reject कर दिया जाए? उस केस में the Honorable Supreme Court in the case of Dalip Singh versus State of Punjab has very specifically and categorically ruled that their testimonies is not to be rejected entirely. But the fact that the witness is an injured eyewitness, also the fact that he's an interested witness because he's somewhere related to the victim, then this brings the court to a guard, and therefore their testimonies must be scrutinized more carefully, and the court must seek the corroboration of the testimonies of the injured eyewitness from other independent evidences. तो for example, अगर मान लीजिए मैं अपने दोस्त के साथ था और अक्यूज्ड आया और उसने मुझ पे चाकू से वार किया और मेरे को बचाने के चक्कर में मेरा दोस्त भी इंजर्ड हो गया. Now the matter has come up before the court, and the defense is pleading that my friend, who is a witness, who is the only eyewitness before this court, cannot be relied upon on two grounds. One, he is himself an injured witness. Second, he is an interested witness because he is my friend. तो वो तो मेरे खिलाफ गवाही देगा ही. तो क्या इस केस में कोर्ट मेरे फ्रेंड की टेस्टिमनी को रिजेक्ट कर देगा? नहीं, कोर्ट रिजेक्ट नहीं करेगा. कोर्ट क्या करेगा कि अगर मेरा फ्रेंड एज अ प्रोसिक्यूशन विटनेस इज टेस्टिफाइंग बिफोर द कोर्ट that whatever I am stating about my assault, that the accused came and stabbed me with the knife, if he is also deposing the same, then the court will seek the corroboration of his testimony from other independent witnesses, other independent evidences. Now, what it can possibly be? So, the medical report, say for example, the medical report, if it says that the injury which has been sustained by the victim was caused by some sharp weapon, and it was grievous in nature, and it was stabbed with a knife, then this gives a corroboration to the testimony of my friend who is an interested or injured eyewitness. This is the first point which gives the corroboration to the testimony of my friend. Secondly, what happens if the investigating officer has deposed before the court that they have seized blood-stained knife from the possession of the accused, and the medical report also confirms that the blood stains on the knife are the blood of the victim, then this confirms the fact that I was stabbed with a knife by the accused, and this also gives corroboration to the testimony of my friend who is an interested witness but also an injured eyewitness. So in all these cases, this is how the court will seek the corroboration of the testimonies. Similarly, is the interested witness. I have also, I've told you just before in the previous slide that in case of injured witnesses, the court comes to its guard. The testimony is not rejected completely, but the court comes to its guard, and the court tries to seek the corroboration of the injured witness with other independent witnesses. So is the case with the interested witness. Now, if the person who is the eyewitness of the incident is my father, or she's my mother, or he's my friend, or somebody else, so in all those cases, they are somewhere related to me. So obviously, the veracity about the testimony comes into question. And if the veracity about their testimony is coming into question because of the fact that they are related to the victim in one or the other way, then in those cases they are called the interested witness. And with regard to the testimony of interested witness, just like what we have seen in case of injured witness, the Supreme Court is of the view, and this was the view expressed by the Supreme Court in the leading case of Shyam Sundar versus State of Chhattisgarh, which is a ruling delivered in the year 2002, that in these cases also, their testimonies are not to be rejected completely, but the court comes to its guard, and the court must scrutinize their testimony carefully by seeking corroboration from other independent evidences. And I have given you an example as to how the corroboration from the other independent evidences can be sought. Then last we have the child witness. Now the fact, especially in all those cases with regard to domestic violence or dowry death, where the women are tortured inside the house, or when they are driven to commit suicides, or when they are killed inside the house, we do not have any other independent witness. We generally we rely on the testimonies of the children of the couple who had witnessed the entire incident, who has seen their father beating their mother, or their grandparents torturing their mothers and driving them to commit suicide. In all these cases, whether the child witness, whether the fact that the witness is a person of a tender years of age, can his testimony be relied upon? Then we need to seek the guidance from Section 118 of the Indian Evidence Act, which says that all persons are competent to testify unless the court considers that they are prevented from understanding the question put to them, or from giving a rational answer to those questions by tender years, extreme old age, disease, whether of body or mind, or any other cause of same kind. And the explanation says even a lunatic is not incompetent to testify unless he is prevented by his lunacy from understanding the questions put to him and giving rational answers to them. What it is saying that what we need to assess before before coming to a conclusion whether a witness is competent to testify before the court or not, that whether he is able to understand the questions which are being put to him. Second, whether he will be able to give a rational answer to those questions, whether the answers are going to get affected due to the reason of tender years or extreme old age or disease of mind or body or whatever kind. Will these factors be coming into the will be a roadblock in for a effective deposition before the court, which will be so effective that it will enable the court to come to a conclusion? Can he give such a kind of a testimony before the court? Then the test which has been given in Section 118 is that if you are putting a question to the witness, if he is able to understand it, if he is able to give a rational answer to it, then his testimony can be relied upon. And therefore the explanation makes it very clear that even a lunatic person who is not a person of sound mind, if he is not prevented by the fact of his lunacy to understand the question and give a rational answer to it, then he will be considered as a competent witness under Section 118. And so is the case with child witness. The leading case with regard to child witness which has been delivered to the Supreme Court is a 1969 ruling of the in the case of State of Maharashtra versus Prabhu Barku Gode, wherein it was similar to the injured witness and interested witness. The Honorable Supreme Court has said that the testimonies of the child witnesses cannot be rejected completely, but the court must be at its guard. It must scrutinize their testimonies carefully and must seek the corroboration from other independent evidences. अगर ऐसा होता कि हम चाइल्ड विटनेसेस की टेस्टिमनीज को कभी नहीं मानते, तो 498A आईपीसी में जो टॉर्चर के केसेस होते हैं, 304B में जो आपके डाउरी डेथ के केसेस होते हैं, डोमेस्टिक वायलेंस एक्ट के अंदर जो केसेस होते हैं, उसमें कभी हमको कोई विटनेस मिलता ही नहीं, क्योंकि यहाँ पे टॉर्चर करने वाले वही सास ससुर हैं, वही उसका हस्बैंड है. तो अगर कोई इसकी टेस्टिमनी दे सकता है तो वो बच्चे हैं, क्योंकि आस पड़ोस में भी नहीं मालूम पड़ता घर का माहौल क्या है. ये सारे एक्ट में प्राइवेट होते हैं कि इसको इस तरीके से नहीं किया जाता कि आस पड़ोस के लोग उसको विटनेस कर सके, एविडेंस कर सके. इसलिए ऐसे केसेस में जो घर के लोग होते हैं उनकी टेस्टिमनी ज्यादा रेलेवेंट होती है. और अगर मान लीजिए टॉर्चर करने वाले उनके वही रिलेटिव्स हैं, हस्बैंड है या हस्बैंड के रिलेटिव्स हैं, तो ऑब्वियसली वो तो अपने खिलाफ कभी कोई गवाही देंगे नहीं. तो जो बच्चे होते हैं, अगर कपल के क्या कहते हैं कोई इश्यूज होते हैं, कोई उनके बच्चे होते हैं, तो वो उस केस में क्या कहते हैं एक कॉम्पिटेंट विटनेस बन के उभर के आते हैं. और अगर उनकी गवाही बाकी इंडिपेंडेंट एविडेंसेस से मैच करती है, देन इन दोस केसेस their testimonies become reliable and relevant for pressing the charges against the accused, that is the husband or the relative of the husband, for coming to a conclusion with regard to the conviction or acquittal. So this is the position of law with regard to the child witnesses. So this was for today, guys. I hope you this session was informative for you. I would like to know your comments about it. And in case if you have any doubt with regard to what you in case if you have any doubt with regard to whatever has been discussed in today's session, you can also put a doubt in the comment section. Now the session is open for question answers. So in case if you have any doubt, you can put the questions. See, chance witness is, it is not necessary that the chance witness will be an independent witness. Now, say for example, if I have my friend who has visited my house and some incident took place. So the fact that he's my friend and he was there for because in my house sufficiently explains his presence there. But he's also an interested witness. Also, he's a chance witness because nobody knew that something is going to happen, and something is going to happen and therefore I should call him to witness the incident. ये तो ऐसा हो नहीं सकता. ऐसा भी एक फैक्ट हो सकता है, इसीलिए सुप्रीम कोर्ट बोलता है चांस विटनेसेस के केस में कि कहीं वो कॉन्कॉक्टेड विटनेस नहीं है, कहीं वो बनाया हुआ विटनेस तो नहीं है, इसलिए उसकी टेस्टिमनी को बाकी एविडेंसेस से कोरोबरेट करके देखना पड़ेगा कि क्या उसकी टेस्टिमनी रिलायबल है कि नहीं. तो चांस विटनेस आपका इंटरेस्टेड विटनेस भी हो सकता है, जरूरी नहीं कि वो इंडिपेंडेंट विटनेस हो. लेकिन इंडिपेंडेंट विटनेस के केस में इंडिपेंडेंट विटनेस भी चांस विटनेस हो सकता है अगर वो मौका वारदात पे उस समय मौजूद था. तो इंडिपेंडेंट विटनेस तभी इंडिपेंडेंट कहलाएगा जब वो प्लेंटिफ या डिफेंडेंट या प्रोसिक्यूशन या डिफेंस दोनों में से किसी से भी एसोसिएटेड नहीं था. उस केस में हम उसको इंडिपेंडेंट विटनेस कहेंगे. लेकिन अगर वही विटनेस प्रोसिक्यूशन या डिफेंस में से किसी से भी रिलेटेड था, तब हम उसको इंडिपेंडेंट इंटरेस्टेड विटनेस कहेंगे. और क्योंकि वो उस समय मौका वारदात पे मौजूद था, तो उसको हम चांस विटनेस भी कहेंगे. बट उस केस में फिर उसको ये एक्सप्लेन करना पड़ेगा कि वो उस मौका वारदात पे उस समय कर क्या रहा था, क्योंकि कहीं ऐसा तो नहीं है कि प्रोसिक्यूशन ने ये वारदात को अंजाम दिया और उसका विटनेस बनाने के लिए अपने फ्रेंड को बुला लिया या अपने रिलेटिव को बुला लिया. तो इन चीजों से बचने के लिए ही सुप्रीम कोर्ट ने हमने जो केसेस डिस्कस किए हैं उसमें कोरोबोरेशन की बात करी है कि बाकी इंडिपेंडेंट एविडेंसेस को कोरोबोरेट करके हमको. Sorry, somebody has asked for the PPTs. Sorry, these PPTs are the copyrights of the rostrum legal. So this is a session, and the PPTs are meant only for the session. So I'm so sorry that PPTs cannot be provided. The proving of the statements under 161 depends upon the fact to fact. Now, say for example, if the accused is saying कि I was hit by a knife, but the medical report says that he was not hit by a knife. उसको किसी हार्ड या ब्लंट ऑब्जेक्ट से मारा गया था, किसी शार्प ऑब्जेक्ट से नहीं मारा गया था. तो पहले डिफेंस उसको बताएगा कोर्ट के सामने कि भैया इसकी मेडिकल रिपोर्ट बोलती है कि इसको हार्ड एंड ब्लंट ऑब्जेक्ट से मारा गया था, बट यहाँ पे ये क्लेम कर रहा है एक्यूज को फंसाने के लिए कि भैया इसको चाकू से मारा गया है. So this is the contradiction. So first you have proved the fact that he was hit by some hard and blunt object and not with the sharp object as is being claimed by the witness, and then you will contradict his testimony because that the fact that he did not mention it in his FIR or he did not mention it in these statements under 161 he was hit by the knife is itself relevant to prove the contradiction of the witness. Rustic witness means who is making a claim. Now, say for example, if you will see the Evidence Act, there are some rustic women, there are some rustic witnesses. Now, say for example, अगर मान लो मेरे साथ कोई घटना हुई और मैं उसका सिर्फ हल्ला किए जा रहा हूँ कि मेरे साथ ऐसा हुआ, मेरे साथ ऐसा हुआ, पर मैंने उसका क्या कहते हैं कोई बयान नहीं किया, मैंने उसकी कोई कंप्लेंट नहीं करी, I will be called a rustic witness. In case where see, in those cases, then 113A, 113B of the Evidence Act will come into question. And if you will see the words, the shall and may presume words have been used. For example, in case of dowry debt, the court shall presume the fact of torture before the death has been proved, then the court shall presume, which means that the court will consider those factors to be proved. Now it will be up to the defense. The burden will now be on the defense to bring all those evidences on record to to disprove those facts, or to discharge the burden, or to contradict the shall presume theory of the prosecution. In case of 198A, 113A says that the court may presume. So may presume means it is the discretion of the court. So based upon the facts and evidences before the court will come to a conclusion with this, whether the fact of torture to women before the death has to be presumed or not. So that is how a kind of a presumption will be made with regard to with regard to offences which have been covered by the four walls of the house. See, as I have told you, in case of interested witness, and I have given you the example कि मैं अपने दोस्त के साथ था, कोई आया उसने मुझे चाकू मारा. इस घटना का मेरे दोस्त के अलावा और कोई आई विटनेस नहीं है, बट एट द सेम टाइम ही इज आल्सो एन इंटरेस्टेड विटनेस. अगर वो इंटरेस्टेड विटनेस है लेकिन वो आई विटनेस भी है, तो उसकी टेस्टिमनी को बाकी चीजों से कोरोबरेट करके देखा जाएगा. अब इन्वेस्टिगेटिंग ऑफिसर बोल रहा है कि हाँ भैया मुझे ब्लड स्टेन नाइफ मैंने अक्यूज के पोजेशन से रिकवर किया, और केमिकल रिपोर्ट बता रही है कि इस चाकू में जो खून लगा हुआ है वो ब्लड ग्रुप मैच करता है, मतलब वो मेरा ही खून है. ऑल्सो जो डॉक्टर की टेस्टिमनी है वो भी ये बोल रही है कि इंजर्ड के पेट में जो इंजरी है वो चाकू से लगाई गई इंजरी है, वो किसी शार्प ऑब्जेक्ट से लगाई गई इंजरी है. तो अपने आप में ये जो फैक्ट्स हैं ये अपने आप में क्या कहते हैं, एक किस्म से इंडिकेशन देते हैं ऑन द बेसिस ऑफ द सर्कमस्टांसेस, कि एक किस्म से इंडिकेशन दे रहे हैं कि हाँ भैया इस विटनेस की टेस्टिमनी को रिलाय किया जा सकता है. Any other doubts, guys? So, so it was a very nice, and I would like to inform every one of you that we are running the Judiciary Masterclass, where we are preparing the students from all over India for the civil judge examination. This is our online live classes. We conduct the live classes for the preparation of civil judge examinations. Currently, we are preparing for the Chhattisgarh, Bihar, Uttar Pradesh, and the upcoming and other upcoming judicial service examinations. Our next batch is going to start from 15th of July from 11 a.m. to 1 p.m. There will be a one-day demo class, and you all are invited for attending the demo class, for the link of which will be shared in your email accounts after the webinar. Early registration. So I hope this session was informative and useful for you, and we will keep posting more. We'll keep conducting more such informative sessions for you. And thank you for attending the sessions. It was a very nice interacting with you. Thank you so much, guys. Thank you so much. It was lovely interacting with you. Thank you.